So the state of California has now asked for the Ninth Circuit en banc panel to uphold the state's magazine ban based on a recent decision out of Maryland dealing with the Maryland ban on so-called assault weapons and their magazine ban. So let's break down what is now happening in the California magazine ban case. Now, really quick before we jump into this video, I want to ask you all for a huge favor. Looking at some of my analytics, about 60% of all my viewers are actually not subscribed to the channel. So if you want to support the channel, if you want this channel to grow, or for this information to get out to more people, please consider subscribing to the channel, and then also just double check because YouTube loves to unsubscribe people. Now, as I mentioned in the intro, I have an important update for everybody in California who's been asking questions about the California magazine ban, and the case we're going to be breaking down is Duncan versus Bonta. You may recall that recently a Ninth Circuit en banc panel essentially decided to break all of their rules, and they took review of the California magazine ban case immediately as a comeback case. Now, that was an unprecedented move by the Ninth Circuit en banc panel, but one of the really good things about them doing that is the fact that the Duncan case is now one of the cases that's furthest along in the process. It's a final merits decision. It's being heard by an en banc panel. And really, it's the next in line when it comes to magazine bans to be heard by the Supreme Court. So that's one of the good things. But we all know that the Ninth Circuit en banc panel is probably going to do everything in their power to uphold this magazine ban. And recently, we talked about how the state of California submitted the 8-1 decision in the Rahimi case as support for this magazine ban in the state of California. And now they have also submitted the Fourth Circuit en banc panel's decision in Bianchi, which deals with Maryland's assault weapons ban, as further support for the magazine ban in California. California now argues that the Bianchi decision out of the Fourth Circuit also shows that a statewide ban on magazine bans does not in fact violate the Second Amendment. Now, for those not aware, Duncan versus Bonta involves the California possession and purchase ban on any magazines that hold more than 10 rounds. This law was originally challenged in a federal district court in front of Roger T. Benitez, who issued a ruling that found that this law in question was in fact a violation of the Second Amendment. Now, after the state of California originally lost, they then appealed up to the Ninth Circuit. And on review, a 3-judge panel in the Ninth Circuit reviewed the decision of the lower court and actually agreed with Judge Benitez, and they found that this magazine ban was unconstitutional. Then the case was sent to the Ninth Circuit en banc panel for an appeal. And on review, the Ninth Circuit en banc panel ruled in favor of the state of California, upholding this ban on magazines. Now, that decision by the en banc panel was then ultimately appealed up to the Supreme Court. A writ of cert was filed, and this case, Duncan, was put on hold, and we were waiting for a decision in the New York State Rifle and Pistol Association versus Bruen case. Now, after the Supreme Court issued the Bruen decision using, text as informed by relevant history and tradition and rejecting the two-step approach, they then sent the case here, Duncan, back down. What they did is they issued a GVR, a grant, vacate, and remanded the case. And this case was sent all the way back down to Judge Benitez. And on review, Judge Benitez simply just reaffirmed his decision before, used some of the language in Bruen, and said, yep, I got it right the first time. Bruen actually shows that I got it right the first time, and I'm going to just rule the same way. But of course, the state of California was not going to accept that. They were not even going to accept that decision in light of Bruen, so then they appealed up to the Ninth Circuit. And here is where things got really interesting with the Duncan case. What ended up happening is this was set to be reviewed by a 3-judge panel in the Ninth Circuit, but then this same panel, the same Ninth Circuit en banc panel that reviewed Duncan before, what they decided to do is take the case out of the hands of the 3-judge panel, and they took the Duncan case as a comeback case. Now, what was also interesting about this whole process is that many of the judges on this same panel had issues with how the Ninth Circuit was handling this case, taking it as a comeback case, and they actively called out all of their colleagues, saying that they were in fact breaking the rules. They were not upholding their, judicial duties. They were violating the Constitution. They were violating the Second Amendment, and they were doing everything in their power to infringe on fundamental rights like the right to keep and bear arms. So there was also a lot of back and forth back in March when this made its way in front of the en banc panel, when there were oral arguments. There was a lot of back and forth between a lot of the judges on the same issue about the Ninth Circuit en banc panel breaking the rules. And now the state of California has submitted not only just the Rahimi case, but also the Bianchi case to the Ninth Circuit as support for why the Ninth Circuit should uphold this magazine ban. Now, in their letter in relation to Rahimi, they argue that appellant writes to notify this court of the 8-1 decision in U.S. versus Rahimi. The Supreme Court rejected a Second Amendment challenge to 18 U.S.C. Section 922 G8 C1, which prohibits individuals subject to certain domestic violence restraining orders from possessing a firearm. Rahimi reiterated that the right secured by the Second Amendment is not unlimited, does not sweep indiscriminately, and is not a right to keep and carry any weapon whatsoever. The court recognized that some courts have misunderstood the methodology of Bruen and Heller, which were not meant to suggest a law trapped in amber. It criticized the Fifth Circuit and the dissenting justice for committing the error of reading Bruen to require a historical twin rather than a historical analog. That is the same error committed by the district court in this case. As the Supreme Court explained, the appropriate analysis involves considering whether the challenged regulation is consistent with the principles that underpin our regulatory tradition. Here, the principle emerging from the long tradition of government restrictions and prohibitions on especially dangerous weapons and accessories justifies the challenged restrictions on large capacity magazines. So here, California is arguing that Rahimi actually supports their magazine ban, and they can show appropriate history and tradition to support a statewide ban on these types of items. And now they're also trying to submit the Fourth Circuit en banc panel's decision on rifle bans as further support for this magazine ban in California. In the new letter to the Ninth Circuit, they argue that the Fourth Circuit considered a Second Amendment challenge to a Maryland law banning assault weapons after rejecting plaintiffs' facial challenge because plaintiffs failed to show that each firearm regulated by the Maryland statute is within the ambit of the Second Amendment. The court considered the constitutionality of Maryland's restrictions on AR-15s. The court applied Bruen's two-step methodology and concluded at the first step that the covered firearms are not within the scope of the constitutional right to keep and bear arms for self-defense. The court further held that even if the text of the Second Amendment were read to encompass the covered firearms, the statutory provisions would nonetheless be constitutional because Maryland's ban on AR-15s is consistent with a strong tradition of regulating excessively dangerous weapons once it becomes clear that they are enacting an inordinate toll on public safety and societal well-being, while nonetheless preserving avenues for armed self-defense. 10 judges joined the opinion of the court, 1 judge concurred in the judgment, and 5 judges dissented. So there, California is trying to use the recent Bianchi improper analysis and decision to uphold this magazine ban in California. Now, in the Bianchi Fourth Circuit en banc panel decision, the panel there argued that in their belief, the AR-15 and similar rifles are useful in military service, and since they are militaristic weapons, a state can outright ban them because they are so dangerous and unusual. We've also seen a lot of times now, some of these courts and also states are arguing for a more nuanced approach when it comes to historical analysis. They are saying that these societal concerns and public interest allow for a broader interpretation based on history. Essentially, this is a way to backdoor in means end scrutiny, intermediate scrutiny, and you're seeing that happen in a lot of circuit courts like the Fourth Circuit, and that's what's being advocated for here to also happen in the Ninth Circuit when it comes to the California magazine ban. But ultimately, I don't think Rahimi or Bianchi is going to change the outcome of this case much. I think the state of California knows that they're probably going to win this when it comes to the en banc panel. And this is one of those cases that regardless is destined to make its way back to the Supreme Court. It's one of those cases that's furthest along in the process. It's already been to the Supreme Court before. It was GVR'd by the Supreme Court before in light of Bruen. And I think it's only a matter of time before this case makes its way back to the Supreme Court, and the Supreme Court is going to have to address this. So for everyone curious about what's going on with the California magazine ban, that's where it currently stands. Those are the new arguments that are being made to the Ninth Circuit en banc panel, and now we're going to continue to wait anxiously for that decision. But of course, if anything else changes, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.